Okay. A confirmation of the number of witnesses and the X base to be used during the trial. Inform the court, or you can give an indication of the estimated time that each of your witnesses will take. That is a prosecution. You disclose the mode of presentation of evidence, whether it is oral, video, or electronic, if there is any conferencing, whether there are any witnesses who will be caught outside the court's jurisdiction so that we can plan for them. If there are any experts to be caught, you give us the biodata of the witnesses in advance, the sequence in which the witnesses will be caught. Basically, for the time being, that is enough. Maybe if on the pretrial date, if another issue comes up, I will remind you. Then the defense, I've heard the prosecution say that at the moment when you are collecting the documents, they ensure that you sign for the documents that you receive. So you will have to confirm that you have received all the statements and the witnesses that the prosecution says has given you. You also insist on receiving the order in which the witnesses will testify. Of course, there could be changes when the trial begins, depending on how the trial court will look at the issue. Sometimes they may require you to, if there is a change of the order, for you to be informed, maybe 2-3 days, in 2-3 days time or 5 days time, so that you prepare for that witness during cross-examination, so that you don't have to take a lot of time. And again, you'll know in advance the kind of evidence that will be presented by that witness, so that you can prepare for them and not take more time than you had indicated during the pretrial. So indicate the time to be taken cross-examination of each of those witnesses. If there are any preliminary applications, like the one that Mr. Mbiu, is it Mr. Mbiu? Mr. Budi wants to present, it has to be done before the date of the hearing. But for this one, we shall do it before the date of the pretrial, so that we know whether they will participate in the pretrial or not. Confirm. Okay, the issue of adjournment, we will address it during the pretrial. If you go through those documents that will be served on you, and you realize that there is evidence that you may not need to object to, please indicate. Indicate if there is any of those documents that are served on you that you'll just allow without necessarily raising any objections. You can go through the exhibits that are provided. If there is one that you find is not objectionable, you can indicate in advance that you will not be opposing that, so that you also don't spend a lot of time on it. Of course, the prosecution must also ensure that the IO is present in court. But now I can see there is somebody watching brief from EACC, so that any issues that require attention can be addressed as fast as possible. So those are the areas that you can prepare for during the pretrial, so that we don't take a lot of time on that particular day. So prepare your pretrial conference alongside those rights. Of course, I will be suggesting that as we move on, now that you confirm the prosecutors who are on record and the defense, I found it very necessary sometimes to create a platform for yourselves, so that like an issue doesn't have to be, you don't have to send somebody to walk physically to each and every office, serving just a letter, which you could have done through email, a common email. That one takes a lot of time. I hope you will be able to share your addresses. And I think for the time being, or on the date of the pretrial, I want you to come prepared. You give us your email address, possibly the telephone, so that if there is any reason why probably a matter might not proceed on a particular day, the court can also can also inform you in time. If there is somebody who has an issue, it can be shared through that platform and what have you. So that is makes it easier for the management of the case, rather than writing a letter like the one that is sent to have been written, and people just walking from one office to another, one office to another. Then some people have not received, others have received. If you're on the same platform, it becomes very easy. If it is used only for that case only. So that's my suggestion. It's not in law, but I think it is better to manage cases that way, so that we can move fast. Because if we rely on the same old way of doing business, we might not be able to deal with these cases as fast as we should. So I'll be suggesting, subject to your concurrence, because I've seen it done in other cases, you can open a platform. It can be a WhatsApp platform, and then you can come up with the rules. What should not be discussed or shared in that, for purposes of that particular case, or even email addresses. Then you can come up with the rules. You can conference maybe after this on the date of the pretrial and say that this is how we want it to be managed, and this will be the administrator. Then you come up with the rules. If you want us to endorse, we can endorse the rules, so that anyone who goes outside the rules, we can reprimand them. But I think that is a better way to do business nowadays. So rather than just having an official letter written, either posted or somebody walking from office to office, just to indicate that I have received the documents. Why don't you share it on the platform or email? And then when you come here, I know you are lawyers, you are professionals. I don't think anyone who is a gentleman or a lady would just come here and deny that they have not received when they have indicated that they have received an email. So I think that is the kind of relationship I want you to have, a professional one, as the case moves on. So just open one group for purposes of this case. Once the case is over, you can decide now that the group has outlived its purpose and do away with it, isn't it? Yeah, so I think next time we will discuss more on this.